Mr. Khan, thank you for your patience as we got reset there. Again, I can see you now. I can hear you. Can you hear me okay and all that?
I can, Your Honor.
All right. So Mr. Masterson, of course, is here, but I believe you'll be.
That's right. Certainly, to the extent that there were questions raised about SNAP's contentions, I do want to be clear, and I'll set on the record, the accident was investigated by people and SNAP was not there. So their contentions are, in fact, based on investigation by others. But we do contend that the plaintiff came into the lane of travel of Ms. McGee and is contributing or causative of the accident. If there's any question in plaintiff's mind about that, we produce metadata, and SNAP's contention clearly is that she was not using SNAP, as is her testimony. And so I just wanted to clear that up for the record, but you're correct. Since Mr. Khan handled these depositions, we thought it best that he respond to the motion, and he's prepared to do so.
All right, and I'll circle back to that. So, all right, Mr. Khan, and do you, hold on just a second, Scott. Mr. Rutledge, when Mr. Khan is finished, do you anticipate any argument? Either way is fine. I just didn't.
No.
Okay, this just didn't seem like something you were central to. But unfortunately for y'all, you will be the center point of the next one, but not today. So, all right, Mr. Khan, the floor is yours.
Thank you, Your Honor. Before I begin, let me say we have not seen in advance the many slides that Mr. Adams chose to show, really in the form of a second briefing. And so I'm going to try and address the claims that have been made by plaintiff on a somewhat high level, focusing on the briefing they actually submitted to the court. And let me begin by giving a little perspective to what actually happened here. This is something that wasn't mentioned at all during Mr. Adams' presentation, which is that these depositions took place over 2 days, that 2 SNAP witnesses gave over 12 hours of testimony, highly detailed, substantive testimony on more than 28 topics that plaintiff did indeed choose, worded exactly as it wanted, including vagueness and broadness of those topics, and was able to ask questions more or less without interruption over the course of these 2 days, over some pretty long days. That's 12 hours on the record, not 12 hours of total time. And the witnesses were not, despite plaintiff's claim, some sort of blank slates. They were people quite high up in SNAP who had extensive knowledge. So, for instance, Ms. Morkajanis had replaced the earlier witness who we had planned to present on product because he had left the company in the interim during the time that we were waiting to take this deposition. She replaced Mr. Jack Brody, and she is the head of product for all of SNAP. Since Mr. Neff and Mr. Adams wished to question SNAP about its product, the head of product seemed an appropriate person to present. Mr. Cheek was the head of partner relationships, and who had extensive knowledge about SNAP's communications with partners and its communications generally, which was one of the main topics that was designated. And yes, as Mr. Adams suggested, I am going to talk about their preparation because their preparation was extensive. And I'll start with Mr. Cheek. Mr. Cheek's preparation began in September. And most of it took place in September and October, and then his deposition was delayed, however, when Mr. Neff and Mr. Adams declined to go forward with the November date presented, so there was some gap. But in addition to the numerous documents that Mr. Cheek reviewed, he interviewed 4 different witnesses and spent many hours with lawyers preparing for the deposition. The same is true of Ms. Morkajanis. In addition to her broad knowledge of products and product development at SNAP, she spoke to numerous witnesses at SNAP, or numerous personnel at SNAP, reviewed documents, and met with lawyers. Each of these witnesses met with lawyers for at least, in the case of Mr. Cheek, 6 to 8 hours. In the case of Ms. Morkajanis, 8 to 10 hours. And so the witnesses were well prepared as they could be, in light of the nature of the topics that were suggested by plaintiffs. And the plaintiffs got detailed, substantive testimony on these topics. And of course, the topics themselves were an issue from the beginning. We did complain that they were overly broad, that made it very difficult to prepare witnesses. In fact, I met personally by telephone with Mr. Neff to try and discuss this, to plead with him to please give us some more specificity so we can make sure the witnesses have the answers to the questions you want. So we're not back here with you complaining that the witness couldn't answer this question or that question. And yet here we are with Mr. Adams having cherry picked through 2 full days of deposition a number of particular excerpts from transcripts. And I'd suggest that the real reason we're here is revealed by the email Mr. Adams sent to the court just days after these depositions, when he hadn't even yet received the transcripts and so couldn't have reviewed them, and wasn't in a position to say in any detail what had happened in the deposition. That this motion was coming regardless of what happened in the depositions, regardless of whether the witnesses answered every question that was asked, regardless of whether there had been no objections from counsel. This motion was coming because plaintiff's counsel was frustrated by this court's direction that a deposition of the CEO of SNAP, which Mr. Neff announced his intention to take before any discovery had occurred and before anyone knew anything about what had happened in this case, that desire had been frustrated by this court's order that we were going to proceed step by step through the discovery process to see what was necessary, if anything, to question Mr. Spiegel about. And that's why this motion was filed simultaneously with a motion, again, procedurally inappropriate motion to depose Mr. Spiegel. Let me try and turn now to the broad categories of specific complaints that Mr. Neff and Mr. Adams have made beyond simply the blank slate and the preparation. And in their brief, plaintiff's counsel leads with a complaint about conferences with the witnesses, and they rely principally upon upon this federal case, Hall versus Precision Instrument, I believe it is. And what they fail to note in making this complaint are 2 important things. First, that the rule itself is clearly a minority rule. In fact, even the citations that plaintiff has provided concerning it show that this is not a widely adopted rule. They're able to point to specific courts in specific locations, and yes, some Georgia courts that have adopted the rule. But they're not able to say that this is a broadly adopted or even majority rule, and it isn't. And the truth of that is proven by the simple fact of what occurred in the deposition. After each break, Mr. Neff asked each witness, both Mr. Cheek and Ms. Morkajanis, did you talk with your lawyers? Did you talk with them about the case? And sometimes if they answered that yes, they had talked about the case, he asked specific questions about what was said. In no case did Mr. Neff raise an objection. In no case did Mr. Neff say we're going to suspend the deposition and go to the court because I think this is improper. And the reason he didn't do that is he knows that this is not a majority rule, that it doesn't govern these depositions, and there was nothing inappropriate. And beyond that, it was clear from what was happening in the deposition that there was no coaching. Mr. Neff, in the end, is able to point to only 1 change of answers by Mr. Cheek, and that regarded the witnesses who he had spoken to and what he had spoken to Ms. Rakusin about. And the court has the transcripts, and I urge the court to look at the transcripts and look at the video.
I've read both of them.
Excuse me, Your Honor?
I've read both of them in full.
Okay, yeah, and I expected that. And if the court looks at that, what's clear from that incident is Mr. Cheek says, no, the lawyers didn't suggest this to me. I realized in the midst of this that I hadn't mentioned that, as to Ms. Rakusin, that he remembered it later. And frankly, had Mr. Cheek not corrected himself, I think I would have been obligated to provide a correction to Mr. Neff, because if I hadn't, he'd be here complaining that, in fact, Mr. Cheek spoke to additional people and he hadn't revealed it to us. They're able to point to no other changes in answers after a conference. And of course, those changes in answer didn't come at the urging or suggestion of lawyers, but because Mr. Cheek, who is not a professional witness, who has not testified in depositions numerous times or taken depositions numerous times, under stress forgot something and then remembered it and offered up the answer. And it's just that simple. The rule in Hall is intended to prevent coaching. It's intended to prevent lawyers stepping in and stopping witnesses from answering until they can confer with them. It's intended to prevent some distortion of the process by which a party obtains information from a witness. And none of that happened here. And a review of the transcript makes that absolutely clear. And nothing Mr. Adams or Mr. Neff have pointed to calls that into question. The second point I'd want to address, again at a high level, is privilege. Mr. Neff is complaining again and again about the witnesses' refusal to answer questions about the investigation. And despite the fact that Mr. Adams talks again and again about facts, that we can't protect facts through work product, there was not a refusal to answer questions about what SNAP knows about facts that were in its possession. And that's what those cases deal with, that the witness can't protect evidence about facts by conveying those to a lawyer and then claiming they're protected by either attorney-client or work product privilege. In this case, what was being asked about were changes to the speed filter and or knowledge about the particulars of this case. And when I mean the particulars of this case, I'm talking about the accident, Mr. Maynard's injuries, Mr. Maynard's damages, that sort of thing. And I point out that first, with regard to the changes that were made to the speed filter, first, the institution of the blackout filter, the range that the filter became unavailable first between 50 and 150 miles an hour and later between 35 and 175 miles an hour, and then finally was eliminated. Those changes all took place after legal actions were initiated. In fact, after Mr. Neff started this action, or I shouldn't say, there was a prior lawyer who I think initially filed it, Mr. Henningsen. It's hardly surprising then that decisions that were going to be made about the speed filter would be highly dependent upon consultations with lawyers. And it's hardly surprising that as a result, the reason for those decisions and the facts that were relied upon in making those decisions would be protected by attorney-client privilege. It's also hardly surprising that SNAP is not in a position to investigate the literally millions of car accidents that happen every year and doesn't commence investigation until legal action is at least threatened. Now, Mr. Adams points to various Google alerts to say, certainly SNAP should have known about this in some way, investigated. These Google alerts are simply, I don't know if Your Honor uses Google alerts or not, but yes, individuals set up alerts so that they can see all the news that mentions SNAP at any point in time. That has nothing to do with whether SNAP commences an investigation or not. And in every case, the investigations conducted of these crashes were conducted by lawyers. The investigation of this crash was conducted entirely by lawyers, and really almost entirely through the discovery process, of which Mr. Neff and Mr. Adams are entirely cognizant and are participating in. So it's hardly surprising that the witnesses were unable to answer questions about these investigations because they are covered by work product privilege. No facts have been shielded from Mr. Neff or Mr. Adams. Rather, the conduct of the investigations by lawyers have been shielded from them, and that is entirely appropriate. They don't get to know about that. Nor were, and I think this is really seems to be in part what's being suggested, nor was SNAP obligated to have these witnesses interview the lawyers who were conducting the investigation so that I would then object and say, no, they can't talk about those conversations with those lawyers because they're privileged. We don't create additional privileged conversations to then object to them. So the privilege objections that were made were entirely appropriate. They concern either communications with lawyers surrounding the changes to the speed filter and the removal of the speed filter, or they concern investigations conducted by and supervised by lawyers that are subject to the work product privilege. I'm sorry, Your Honor, I'm just checking my notes to make sure I cover the various issues that Mr. Adams raised today.
That's perfectly acceptable. And I'll just go and tell you, your connection is about 98% perfect, but there's just a couple of moments where we lost a word or two in there. So just you're at a good pace. So just make certain you keep that pace as you keep going.
Okay, I'll try and keep this pace. And Your Honor, if there's something I say and it doesn't come through, please feel free to interrupt me. And I'm happy to try and repeat what I've said. There's also complaints about the objections that were made by me during the course of the during the course of the deposition. But if Your Honor looks at the citations that Mr. Adams provided in his lengthy PowerPoint, very few of them are in fact speaking objections at all. And in fact, I think very few speaking objections were made other than when Mr. Neff and I began arguing with each other about particular things. And Your Honor's read the entire transcript, so you know this was a contentious deposition, knows that, in my view, much of Mr. Neff's questioning at particular times during the deposition was quite argumentative, and things did become heated at certain moments. But the objections reviewed in context were entirely appropriate, and instructing the witness that they can answer if they're able is not improper. Yes, Mr. Adams is able to dig up one case, but we can all dig up one case or to say almost anything if we want to. And I think those of us who have done many depositions, who have sat through them, know that it's a very common instruction to the witness: you can answer if you're able. As well as the instructions that they can answer instructions concerning privilege and instructions that they could answer to the extent they were able to do so without revealing privileged communications. Those instructions are not only appropriate, they're necessary. There is no other instruction that could have been given in those circumstances. Your Honor, I don't want to go on at length. As I said, I think the transcripts really speak for themselves. They speak to the fact that, again, that these witnesses were knowledgeable, that they were prepared, as well prepared as they could be, in light of the extremely broad and vague nature of the 28 topics that they were required to answer on matters going back many, many years. And Mr. Neff still has one more deposition, as I understand it. They've noticed additional topics concerning data, and a number of the questions that were not answered in this particular deposition are properly topics for that witness because they go to data, including why certain data was collected or not collected and what SNAP's ability to collect that data and the specifics of it. And I'd urge the court that there is no reason for action at this point, that nothing about SNAP's conduct in either preparing these witnesses, representing these witnesses, or objecting to certain questions on behalf of the witnesses was in any way inappropriate and that the court should allow the deposition process to continue and allow us to complete these 30B6 depositions, and that if any follow-up discovery is necessary at times, as the witnesses themselves suggested in response to certain questions, I don't know the answer, but we can provide that follow-up discovery is done. And then you can then see where we are and see if there's actually information the plaintiffs are entitled to and need that they don't have. And that's the appropriate way to proceed in this matter, Your Honor. I'm happy to answer any questions. I know I've spoken much more briefly than Mr. Adams and a much higher level, but I was prepared to address largely what was set out in their briefing and not the many specifics that was raised instead in the PowerPoint that we hadn't seen in advance.
Okay. All right. Thank you, Mr. Khan. Mr. Masterson, do you have any follow-up? Obviously, y'all are both co-counsel then. Just want to make sure.
Not at this point, Your Honor.
All right. Anything you wish to present on this, Mr. Rutledge? All right. So we're going to come back to Mr. Adams. Do you wish to respond in any way?
Just for a few seconds, Judge. Thank you.
The floor is yours.
Yeah, thank you. First of all, the PowerPoint, we haven't cited any new cases, no new arguments. You see this all the time. A detailed correction. I don't recall us declining to go forward with a deposition date. I do recall SNAP canceling a deposition date after we had booked travel to LA. So I don't want there to be any impression left in the court's mind that the plaintiff delayed the depositions. Interesting about contentions, we got more from Mr. Masterson in his prefacing remarks than we got from the witness. SAP says we contend that Mr. Maynard came over into her lane. We contend and we contend. Well, we didn't get any of that from the witness because it was privileged and or confidential. And that's not how that should work. And one minor point, there was no alternative to saying objection, you can answer if you're able. Well, I defended a couple of depositions in my day, and all I will say is objection, you may answer, or objective form, you may answer. You may answer. If you say if you're able, especially with a witness who has been prepared, the witness is not going to be able. Because that's what the witness is going to do. And the last thing as I sit down, SNAP had these topics for over 7 months before the depositions actually took place. The court did not receive a motion for a protective order, so it could rule upon any objection SNAP had, and it was not in SNAP's power to unilaterally decide that a question was too vague, and we're just going to wing it, or we're not going to answer it for. Yeah, the court did address a couple of objections, and I noted a few in my hearing notes. I don't know if my notes are incomplete or if these are only ones we talked about. For example, I remember topic 11, the court said, this feels like comfortable discovery territory to me. Number 30, the judge said, I'm not troubled by this very reasonable request. So I don't have any topics. We didn't go forward on any topics which this court had occasion to consider and said, this is inappropriate, this needs to be redone, this is, or even I strike this topic. That's it. Thank you, Judge.
Okay. Mr. Masterson, the floor is yours.
Thanks, Your Honor. A couple of things. So when I point out the contentions, right? So this is, you're asking the questions of the company of things that they have factual knowledge of. Okay. SNAP was our contention, not being used in the car, number one, which is very important, but I'll skip. But also certainly no one from SNAP was there to witness it. The witnesses in the case that have facts that they are to discover are the people who were in the cars who looked and the police officers who's investigated it. Those people, the police report is well known to them. And so the information they have is the same as what SNAP has. Everything related to interpreting that information and making it into a legal contention does come from the lawyers, which is the only point that was made related to work product and privilege. SNAP itself did not go out and investigate the accident. They sent accident reconstructionists and they sent lawyers and other witnesses to do so who will testify when given the chance. One thing I'll point out about the PowerPoint, watching it firsthand, having read the brief myself, though it wasn't my charge to argue it, is that a lot of the cases, if not all of the cases, in these snippets from the cases were not Georgia cases. And I say that only because counsel did not point that out, as I would expect. He did in one instance, but he didn't throughout when he cited cases from Utah and Nevada and Florida and other states, instead of that, which is the Georgia law. And last, and maybe most importantly, I said when we first discussed this informally about this process, I think I predicted it. I said, Mr. Neff's going to take hours and hours and hours and hours and hours of testimony, and then he's not going to be happy with the answers he gets. Okay, and so we actually did, in addition to what Mr. Khan has already stated on the record, we have reached out to them and we have tried to narrow and get to the things that they want answered that they are entitled to ask a corporation about, to narrow it to something that can be answered, right, by these witnesses. And they just flat out refuse to do that, which begs the question of why are they now complaining when Mr. Reuben Khan in the deposition says that the question you're asking is vague. When we sent him objections before the deposition, said, these are vague. I mean, we were giving them notice of that position, Your Honor, and they refused to do anything about it because they don't want to do anything about it. They want to complain about it later, and they want to use it as some platform to get what their ultimate goal is, which they've already stated to the court, which is to depose Mr. Spiegel. But I'm going to come to that in a minute, so I'll save that for the motion that's to come in the interest of time. Thank you, Your Honor.
All right. Anything else on this topic? All right, I'm going to step off the bench. I want to review a couple things with Mr. Hague before we pivot to phase 2 of this. So, Mr. Khan, I'm going to mute this because we're live streaming and I'm not going to shut off the live stream. So you definitely want to mute yourself on your end. And then when I come back out, I'll unmute it, okay?
Thank you, Your Honor.
All right, and you feel free to shut your camera off, Mr. Khan, while we're on break.
Your Honor, just for housekeeping, I have another PowerPoint. I don't know if that applies.
I can switch to it. It's the switching back that it hiccups. So. All right, we're unmuted. Mr. Khan's still up there, and you ready for me to move the screen up for you? All right.
Yes.
Mr. Khan, can you see the PowerPoint okay?
I can, Your Honor.
All right. Okay, floor's yours.
Thank you. Right, this is our motion to depose Evan Spiegel. And, you know, I think SNAP's primary argument is Mr. Neff wanted this all along. And Mr. Neff has engineered everything, has masterminded everything to get to this point. And I think one of the things SNAP is overlooking is that yours truly got to go through 45,000 pages in Lemon before this case got started. So we know things from reviewing those before we even got to work in this case. But there's rhetoric and there are facts. And I have a feeling that the judge spends a lot, and Mr. Holt, you spent a lot of your day parsing through the former and getting to the latter. So what we're giving you today is what we think are facts that make it abundantly clear that we ought to depose Mr. Spiegel in this case. Mr. Spiegel is one of two people. What do I mean by that? Well, at the time SNAP released the speed filter, it had 35 employees. The speed filter was released on December 20, 2013, and Forbes wrote an article on January 6th, it's about, 2 weeks later or so, and it said SNAP has moved 3 times since initial investment, as the company has grown to a still lean 35 employees. Okay, that's nice, but let's get into discovery. We asked Snapchat, who conceived the speed filter? And Snap gave us a list of, 7 names. And, and the last column says employed by Snap, and you can see only 2 remain. Okay, well, who approved the release of the speed filter? Once again, we have a list of 7 names, only 2 remain at Snap. And of the 2, the Robert Murphy was apparently not involved, according to Snap's testimony. According to Ms. Morkianis, I kind of surmised that he hadn't been kind of involved in this very deeply. Well, we have one more discovery request to show you. We asked who approved removal of the speed filter. Identify the person or people. And Snap gave us 1 name. The following individual played a role in approving the removal of the speedometer sticker, Evan Spiegel, CEO. So actually, Mr. Spiegel is 1 of 1. He has unique personal knowledge that is important to the case. And those aren't my words. You'll see in a moment. Both of Snap's 30B6 witnesses claimed a need to interview Mr. Spiegel regarding creation of the speed filter, prior cases involving the speed filter, Snap's investigation of the case, his conversations with Mr. Allen during the design process, why Snap blacked out speeds between 50 and 150 miles per hour, and Snap employees' comments about a perceived risk of the use of the speed filter. And we asked Mr. Sheen, why did you ask Spiegel about these things and not someone else at Snapchat? And in his own words, because we thought his knowledge of the subject was important to the case. Now, yes, Mr. Spiegel's memory, according to the 30B6 witnesses, was quite poor. He couldn't recall specifics. He couldn't, here's one, it's interesting. What did he have in response to your question about Snap employees' comments about the perceived risk of the speed filter? He didn't surface any specific employee. And Mike says, he didn't what? She said he didn't, he discussed and affirmed he had seen the email from Micah, but he didn't remember it and didn't recall conversations about this. Well, let's take a sidebar and talk about internal employees and their comments about the speed filter. Snap engineers have discussed it. And in 2015, one said we should remove the range of 20 to 150 miles per hour for external optics reasons. That's interesting because that sounds like a lot like what Snapchat said was the work product of council. Well, Mr. Yaffa was one of their engineers. Sounds like we're tempting folks to commit stupid acts. I don't like it either. Ilya Hakinson, another engineer. See my note below. We will need to remove fast speeds achievable by car. This is all in 2015, before this crash that brings us here. And this is another engineer. But Mr. Spiegel doesn't remember or know anything about internal employees' comments about safety. Now, Ms. Morkianis said, I asked Mr. Spiegel, why did Snap black out speeds between 50 and 150 miles an hour? And she says he didn't have specific recollection of the time period and how it happened. He didn't share anything specific about that. So his memory, according to the witnesses, wasn't great. And it's almost as if they're saying, we did the work, Mr. Neff, Mr. Adams, so you don't have to. That's not how discovery works. The Georgia Supreme Court has said, poor memory does not provide grounds for a protective order. And that was in a case specifically about deposing high-ranked executives. General Motors LLC v. Buchanan, Supreme Court case 313 Georgia 811. And in that case, the court said very often discovery is sought to uncover what witnesses do or do not know and reveal inconsistencies between witnesses. CEG, and I put it in bullet points, but this is just all a block citation by the Supreme Court. See Flower v. TRA Industries, Inc. That's a Washington case. Claimed lack of knowledge does not provide sufficient grounds for protective order, as the other side is allowed to test this claim by deposing the witness. Kuwait Airways Corp. v. American Security Bank, N.A. That's, looks like a district, Washington, D.C. District Court opinion. Again, these are from our Georgia Supreme Court citation. The reason why the chairman's alleged lack of knowledge is not a sufficient ground to prevent a deposition is obvious. The very purpose of the deposition discovery is to test the extent of the deponent's knowledge and claims of ignorance. And the last case cited by Georgia's Supreme Court on this issue is Travelers Rental Company v. Ford Motor Co. That's a Massachusetts District Court case. And it said, the plaintiff is entitled to test the claim of lack of knowledge or lack of recollection by deposing the witness. So this is our Supreme Court case. And we'll talk about this case more in just a few moments. But Mr. Spiegel had hands-on involvement with the details of the speed filter. And by that, here's an example of an email. This is from Micah Schaefer directly to Evan Spiegel. Make sure we display a warning about not using while driving. He was involved in designing the warning. This was Nick Allen, who we mentioned during Ms. Morkianis' deposition. Mr. Spiegel doesn't remember conversations with her, but Mr. Spiegel and Nick Allen emailed, and it said, hey, this is Nick Allen saying to Evan Spiegel, hey, wanted to get your feedback on what we're going to display. Number one, the first time the user goes to the speed filter, open parentheses, please don't snap and drive. And here was the second page of that email, or the attachment to that email, in which he's asking Evan Spiegel to look at several models for the don't snap and drive warning. This was back in December of 2013, before the speed filter was released. Mr. Spiegel was even involved in deciding the font and design of the speed filter or the warning. Evan Spiegel, November 19, I believe that's 2013 as well. Note here, need to use images, not fonts. And apparently that's in response to Nick Allen talking about what font they were going to use. So we're not talking about a CEO, an executive who is far removed, who is managing 1,000 employees and really has nothing to do with the detail. This is, in this particular case, this is an individual who had direct hands-on experience, him and 34 other employees were involved at the time the speed filter was released. And Snap has told us he was the one person they named who authorized the removal of the speed filter. So now Snap, I told you we'd come back to this case, Judge. Snap argues that General Motors v. Buchanan is no longer good law in light of OCJ 91126.1. This is incorrect. Here's what the Georgia Supreme Court held. Accordingly, we decline to adopt any version of the Apex Doctrine that shifts the burden to the party seeking discovery. And here's what 91126.1 says. The party or person seeking the protective order has the burden of establishing the factors listed in subsection B of this code. Now, once again, the movement has the burden. And here's what subsection B lists. 1, the person is an officer, and 2, lacks unique personal knowledge of any matter. It is impossible for Snap to say of Evan Spiegel that he lacks unique personal knowledge of any matter relevant to this litigation. We've showed you what Snap has told us about his knowledge and involvement. He's the only one left, and he had direct hands-on involvement in designing, releasing, fine-tuning the speed filter, and ultimately the removal of the speed filter. Now, much of Snap's brief is focused on Buchanan being subsumed by statute, but our entire motion, except for one section at the end, is talking about Evan Spiegel's unique personal knowledge. And at the end, we cite Buchanan. So even if Buchanan was no longer law, and even if we just had to proceed entirely under the statute, the outcome is exactly the same, because he has unique personal knowledge. Now, and this is it. This is my conclusion. Snap's witnesses demonstrate that by the questions they claim to have asked him, that he's the only remaining person at Snap's had to ask about at least the creation of the speed filter, prior cases involving the speed filter, Snap's investigation of the case, his conversations with Mr. Allen during the design process, why Snap blacked out speeds between 50 and 150 miles per hour, and Snap employees' comments about a perceived risk of using the speed filter. If he doesn't remember, he doesn't remember. Well, but they don't get to tell us we can't depose him because he doesn't remember. And I am fascinated. I can't wait to hear the substantive reasons for why we should not be able to depose Mr. Spiegel, other than Mr. Lefkowitz wanted this all along, has somehow engineered this litigation to get to this point. I think the facts are unavoidable and cut through any rhetoric that either of us can offer. Thank you, Judge. Thank you.
All right, Mr. Messer, do you say a point for this one?
I'll take this one, Your Honor.
It's all yours.
Thank you, Judge. So I was surprised to see this motion. Okay, I wasn't surprised strategically. This isn't rhetoric. I mean, they said it directly to the court and noticed the man's deposition before they took a single fact witness about what actually happened in the car and whether the app was being used, because they want to leverage taking Mr. Spiegel's deposition to try to get us to pay money, despite the fact that the fact witnesses in the case say that the driver of the car was not using Snap as part of the accident. The only person who describes it otherwise describes it completely incorrectly in a way that was physically impossible. Understanding that may create some question of fact in the court's mind, we do understand that allows discovery to Snap. We've just talked about in the prior motion 12 hours of depositions that have occurred. But the reason I was surprised that this motion was made at this time is because it's completely and directly contradictory to what Your Honor asked the parties to do, right? You said step by step, and because they asked to depose Mr. Spiegel before, and we said we raised the same argument we're raising now, which is not necessarily that that they're right or they're wrong, but that they're premature in this request to the court. They haven't even finished the corporate representative that they put through 12 hours of topics on 12 hours of deposition on 38 topics. They still have partial of 15 of them left, some of which is the information about metadata that answers the question as a matter of technology as to whether or not this lady ever used the SNAP filter, the speed filter from SNAP in her life before, including during driving that night, right? And they haven't finished that, right? Which might be something the court might weigh in looking at the undue burden versus what this gentleman has in the way of unique knowledge that might be relevant or probative to this case. They haven't taken any fact witness of any of these other SNAP witnesses. Mr. Adams just put up documents showing these engineers that they're referencing that had communication about this. They haven't asked or taken those depositions. I'm not suggesting that all those people would necessarily be relevant, because there's only so much that one can expect to be remembered beyond the email itself when you're talking about an email from 9 years ago. But they've taken zero or requested zero fact witnesses to see or to test whether or not Mr. Spiegel is the only person who has unique knowledge. And at the end of the day, before the court can analyze this, that information needs to be known. And by their own motion that preceded this motion, they've said to the court that they said, Judge, we don't have the information from SNAP. We haven't finished this deposition. Presumably, they're going to take us up on the offer of the designee for the other topics. And once that's complete, then there will be a better set of information and data for the court to analyze. The court can look directly at whether a question has been answered by other witnesses who have similar knowledge. The court can analyze whether or not this witness, as the CEO, has unique knowledge that the plaintiffs are entitled to, and make that decision at that time. And I'm not going to argue the statutory requirements for that at this point, unless Your Honor asks me to, because we're not to the point where the analysis and the argument can be made, because they haven't done what Your Honor asked them to do, which is to finish the deposition of the corporate representative, take the other fact witnesses in the case, and then we would address that issue. Thank you, Your Honor.
All right, Mr. Rutledge, do you wish to speak into this at all?
No.
I just want to make sure you have the opportunity. Does Mr. Khan anticipate addressing this?
I don't think so, Your Honor.
He's here. I can see him here. I just can't get him up to the screens. So.
Okay. No, Your Honor, I wasn't going to speak to this issue. Only Mr. Masterson was. I'm happy to answer questions if the court has questions of me.
No, I just want to make certain I'm checking all my boxes as I go. Adams, if you wish to respond, you may at this time.
Thank you. I think it's worth repeating. We had 45,000 pages from Lemon. I didn't have a single gray hair before I reviewed each and every one of those. And
I just realized we should probably define limit a little bit. We know it, but Ms. Leach does not.
Yes.
Otherwise that will not be clear when the transcript is read later what we're talking about. So if you don't mind just taking a minute and clarifying that, so that whoever looks at this later who might not know limit.
my pleasure. Lemon v. SNAP, L-E-M-M-O-N, was a Wisconsin case which we brought before this case, in which three boys. It's filed in California, but the incident took place in Wisconsin, where three boys died in a fiery crash while speeding using Snapchat. Of course, as they do here, Snap disputes that. That case was brought and went through the appellate process, was reinstated, and ultimately resolved. But Snap produced 45,000 pages of documents in that case, and there was an agreement that those documents could apply to this case, except as they pertain to individual users. So all of the documents we put up here in discussion of Mr. Spiegel were produced in that case. And I had personally reviewed them, and I knew those documents existed. And so our request to depose Evan Spiegel is not some grand strategy to somehow bring Snap to its knees by deposing Mr. Spiegel. It is based on the documents we've shown the court. We've attached his exhibits, which show that he had a direct involvement. I was waiting for a citation that says that we must exhaust all other discovery before deposing Mr. Spiegel, and I did not hear that. I did not see it in the briefs. It's not Georgia law. It doesn't exist. Georgia law is set forth in the statute. It's set forth by the Supreme Court, and there is no obligation that the CEO, if deposed at all, gets deposed at the end of the case at the close of discovery. As you heard, Judge, as we just displayed in the prior motion, the witnesses both said, we went to Evan Spiegel to ask him on these issues. Why? Because they weren't there at the time and they didn't know. One thing we brought out in the motion, but not in the PowerPoint or in our oral argument, is that the way Mr. Spiegel's name came up after that infamous break is that Mike had been questioning the witness on a meeting Mr. Spiegel had convened on new litigation in the speed filter. And the witness said, I don't know what that means. I have no idea what that was about because I'm not Mr. Spiegel. I wasn't there. I can't read his mind. At that point, counsel said, we need to take a break. And we heard what happened. We came back and the witness suddenly remembered that he had spoken to Mr. Spiegel and Mr. Spiegel don't know nothing. So the question is, can they do that? Can they insulate him by casting aspersions, or do they have to cite a legal basis for blocking the deposition? And does the court have to find that this is not a person who had personal involvement? I think the latter is the case. There's law, there are facts, and that is what this is based on. Yeah, thank you, Judge.
Mr. Messer, follow up?
Well, I would say that I didn't, I guess I didn't cite that case during my argument. I cited to what was the direction of the court, which is what I believe was intended that we follow. I'll stand by that, try to do what judges tell me to do.
You did. Those were my directions.
Okay.
So
All right. But I would note, just since we're doing procedure for a minute, that the case that the plaintiff cites in their brief describes the appropriate procedure. He's correct that 911-26.1 follows and is statutory and probably ought to be the law that is followed here. But even in that instance, the plaintiffs noticed the deposition, a protective order followed, and this balancing that I've suggested is the law in Georgia that ought to be done, followed. That is the correct procedure. This motion, as I said, I was a little surprised by, one, procedurally, and two, based on the timing, based on your Honor's prior direction. But even if this was appropriate, I didn't make the argument that you have to depose everybody in the world to prove uniqueness, but you got to do something to complete the deposition you have noticed before you come and ask for relief in the form of suggesting that this person is unique. And just because one of the deponents so far, designated as a corporate representative, asked Mr. Spiegel to see if he had knowledge about it in addition to other witnesses, does not necessarily mean that or satisfy their burden that he has unique knowledge when compared to the burden of deposing the CEO in a case where the metadata suggests that the speed filter was not being used. That's all, Your Honor. Thank you.
All right, thank you. All right, anything else on any matters? I'm going to go talk to Mr. Hope just a minute, make certain that I've got his questions answered as well as mine before I come out and wrap this up.
Gotcha. Thank you, Judge.
Okay, all right, well, we're in recess. Again, I know you can't see Mr. Conlon, he's up there. Mr. Conlon, make sure to turn your mic off while we're in recess. right, let's come back to order. Okay, so I'm actually going to issue my ruling. I'm actually going to rule for the bench. I don't normally do this, but I put a lot of time getting ready for this. You all gave me the privilege, as I've said this a million times, it is a privilege being the judge on this case. I have top tier lawyers doing a top tier job. Y'all brief beautifully. You all write great, whatever y'all use proper grammar and I don't. So there, that's in the transcript. But the short answer is that I mean it when I say that you all are amazing attorneys and it's a pleasure to have each and every one of you in front of me. But obviously, for Snap's side, y'all are well aware that I didn't want you here. I mean, within 30 days of taking the bench, I'd already been working on that order for 90 days. I sat there in that seat before I even came on the bench, took notes, and Judge Essery handed that to me when y'all filed it, basically. It said, "This is going to be yours, Merry Christmas." And so I was very convinced that Snap was not supposed to be here. They put you back in, I kicked you back out again. And then they put you back in again. So the plaintiffs had a rough couple of years where I was very solidly against their position until the Supreme Court told me very clearly that I was wrong. And so y'all got back in. My point is that this case is old. It's years in the making. And the fact of the matter is that my position on it has been, let's get moving. Let's just do the depositions. If we have to do a couple of them twice or do a follow-up, I'm okay with that because we've got to get moving. So I need you to know, pointing back at Snap, that obviously, I didn't want you here in the first place, but I was told I had to invite you to the party, and so you're here at the party. And I expected you to participate fully in the party. I need you to know that when I read Cheek and Morgianis, when I read their depositions, I was incredibly frustrated by those depositions. And here are the statistics that I pulled out that left me very frustrated. Cheek's deposition is 166 pages. There were 79 objections from Mr. Khan alone in 166 pages. That's probably more trial objections than I've had in 6 years. There were 27 I don't knows. Now, I am well aware that the purpose of a deposition is to get to I don't know. I know that. But 27 I don't knows, it was to me unacceptable. There was one moment where you all got in an argument about let's call the judge. And I kept thinking, why didn't you call the judge? I do a conference call, and I know that, Mr. Neff, but it was on the defense side that it ended up not being called the judge. So I'm just saying there were speaking objections. Mr. Khan can certainly try to qualify them as not, but Mr. Khan could have instructed his witness at the beginning, answer it if you can, don't answer it if you don't. That could have been a great instruction at the beginning, and the witness probably would have remembered, hey, if I don't know, I probably shouldn't answer. But every time it was asked, Mr. Khan interrupted with the same objection and then instructed the witness how to answer. And that was very frustrating to me, that it absolutely derailed, in my opinion, the purpose of that. Morgianis was just as bad. 327-page deposition, 83 objections from Mr. Khan, 55 I don't knows. Spiegel's name came up over and over and over. Had to talk to him. Didn't know I had talked to him yesterday. And I'm going to go ahead and say, this is Evan Spiegel, CEO of Snap. If somebody had a conversation with him the day before a deposition, that would have been fresh and recent and real. And I was offended when I saw that. And I thought, what in God's great green earth is going on? I was very clear with Snap that what I wanted from them was to designate as many people as were needed to answer the questions. I'm going to tell you, in my mind, Snap was going to have 100 people sitting outside that lobby who were all able to answer one question. Your subject matter of that one question or that one topic, because there were multiple topics. So you can just say, hey, witness, you're in charge of this specific topic, topic 33, topic 18, topic 12, whatever the topic was. But instead, y'all picked two people for a vast majority of them who said in together, what is that, 55 and 27, 82 I don't know. So I'm going to go ahead and tell you, my opinion of those two depositions was that that was a colossal waste of time. And I was angry when I read them. And I am glad I read them several days before this court date, because when I read them, I was very frustrated. And this is me after calming down several days. So I just need you all to know that I am incredibly frustrated. And yes, y'all have big personalities. That's okay. Trial lawyers are supposed to have big personalities. I am great with that. Mr. Masterson, Mr. Neff, Mr. Khan, I am not expecting you all to start a supper club and hang out after this case is over. But the fact of the matter is that I thought Mr. Neff's questions were on a whole, and I'm not going to go through each and every objection in here. If I need to, I will. But the fact of the matter is that I thought the majority of these objections were frankly to disrupt the orderly flow of the deposition, which we all know is a strategy. You know, I remember going to the defense counsel when I was a defense attorney, and they would ever say again, hey, if you ever think this prosecution's case is going too well, just object to something and do a speaking objection, because man, then you could really get them off guard. So, and to me, that kept coming back in my mind. Hey, when in doubt, object, and when in doubt, do a speaking objection, because it'll throw off their day. So I'm frustrated, and I think it's apparently clear that I am really frustrated. So, draw an order. I'm pointing at the prosecution. Sorry, you're up here. I could only do prosecution or plaintiff, so prosecution level. Sorry, I'm pointing at the plaintiff's table. Draw an order. Y'all are going to do these again. SNAP is going to pay for whatever the travel costs are for whoever needs to go out there. It needs to be equivalent to whatever it is y'all stayed at, whatever your tickets were first time out. Do not get in a fight about it, or I'm going to upgrade them from coach to first class. So pay for it. Don't fight about it. Get it done. So I'm just telling you to be equivalent. And if you call me and say we can't agree, then they're going to get first class tickets, and I'm going to put them up at the Westin or whatever. So go back out there. Do this again. Appoint people who can answer questions. Appoint 100 people who can answer one question. And I'll tell you the exact moment that I got really angry. And it was in the middle of, hold on, I made a note that I wanted to put this in the record. There it is. Cheek's deposition, page 96, lines 1 through 3. And when I read that, I thought, well, that's the answer to the question. Because the deposition reads, no, that's why I can't find it. I'm in the wrong person. There it is. All right, so on page 96 of Cheek's deposition, Mr. Neff asks Cheek, who was identified as being responsible for safety in 2013? Answer, I don't know who that would have been. Well, in that time, SNAP only had a couple dozen employees. I don't know the exact number, but I knew it was a couple dozen employees, or maybe 100, or maybe 200. But my moment when I saw that is I thought, I know who knows the answer to that question. Evan Spiegel. Of course he knows who was in charge of it, because we have Sid Essery here. As you all well know, Judge Essery. He has a wealth of institutional knowledge. When I want to know something about the history of this court or what's going on, I don't go look it up. I go talk to Sid Essery. And I say, hey, Sid, who was in charge of this back in maybe the early 2000s? And he'll go, oh, yeah, so-and-so was in charge of it from 2001 to 2004. And then they left to go somewhere else. And he'll tell you a very amazing, very well detailed, frankly, very accurate story of how things got. Well, guess what? You got two people left in the room for y'all who can do that. So the short answer is that I don't remember the name off the top of my head of the first person who can answer that, but y'all are going to talk to that person first. And then you're going to get to depose Evan Spiegel, because at this point, I am so frustrated that the SNAP put up witnesses who didn't answer the questions to the basic level that I expected those questions to be answered. that I see no reason to stall the Evan Spiegel deposition anymore, because we're just going to end up back here with round two with Snap saying they haven't finished it. And I'm well aware that I said from the very beginning, you're going to go depose every single person you need to depose. And so I want to make certain this is very clear. Mr. Masterson was 100% correct. I told the plaintiff, you're going to depose everybody you need to depose. And the questions left on the table, you're very likely going to get to ask Mr. Spiegel that, but it's going to be about this wide. I'm holding my hands up about 2 inches apart. And that's what you're going to get to depose them on. But the fact of the matter is that we're here now. We are almost 10 years into this case. The depositions, just getting them scheduled, have been a nightmare. And the fact that we just wasted all of our time doing this is proof to me that, frankly, I think we just need to go depose Evan Spiegel. And I'm not going to put guardrails on them. Obviously, don't go outside of what he has personal knowledge of. And when y'all do that, I'm going to be on the call, or I'm going to be available to head off anything else. We'll figure that out when we get there. But the fact of the matter is that y'all need to draw an order saying that y'all are going to redo these 30B6 depositions. And Snap's going to pay for it, and Snap's going to pay for the court reporter, and y'all are going to do it right. Because like I said, that is, when I read these depositions, I was so very frustrated. Mr. Adams, do you have anything else from me that you need to know about before you go and draft this order?
Thank you, Judge. Does the court have a position or on attorney's fees involved in bringing this motion?
I've thought about that, and the short answer is I don't. What I'm going to wait on is, what does round two look like? So I'm telling you, so the answer is, yeah, they're on the table. No, I'm not awarding them. But I want to read the depositions from round two, and then I will decide. Because I'm going to include it as a whole. So please put in the order that attorney's fees will be withheld, but are on the table until the resolution, frankly, of the depositions referenced in this order, which are both that one and Spiegel's. So, Mr. Masterson, I think the world of you, but this was not what I expected. And there were very specific factual questions that I thought were incredibly reasonable for them to ask, such as, what do you know about the facts of the accident that were objected to as attorney-client privilege? Which I'm like, well, you know what, it might be, but the fact is that if y'all ended up with an incident report in your file that for some reason no one else has, then you would have ended up with, because I've seen this, where like there's a page the page was left off the back of the incident report given to one side. I see this all the time in criminal cases. Well, y'all saying that this was attorney-client privilege kept them from being able to, because there's value in confirming what the other side has and making sure what the other side has is the same as you. And y'all put everything under the umbrella. I'm overstating it for dramatic effect, but it felt like every time they got to something close that I thought, yeah, we need to answer that, it became attorney-client privilege or privilege. And so I just, again, need to let y'all know, y'all had a really good run, and you got me to kick you out twice. And I would have loved to kick you out a third time, but I was told I'm not allowed to do that again. But you're here, and you're here now, and I'm stuck with you, and you're stuck with me, and y'all have got to fully engage. So, yeah. Mr. Masterson, I'm sorry this ruling went so badly against you, but it did. Are there any questions I can answer for you, or is there any access you need to the record, to protect yourself as we move forward?
Sure, please. First, I don't read the Court of Appeals order as saying you can't kick this case out again. It says that based on what was pled at the motion to dismiss level, accepting that as true, then the ruling was inappropriate. I still think you got it right both times, Your Honor, and I think ultimately that'll be proven. But I say that, and I say that for dramatic purpose as well, since we're doing that. I understand Your Honor's ruling. I heard you loud and clear, and I want to answer questions that are relevant to this case. But in those 12 hours, not every one of those questions is relevant to the case. And the argument that was made today, there's some things that I just don't think, in my judgment, are relevant to the case. That's not to say this, you're not right, Your Honor, about some of those questions should have been answered. I'll give them that. Okay. However, I still have a job to do with the guardrails that you mentioned, right? Like, I mean, they're going to go in there and ask about all these accidents in 2016, 17, 18, after this accident, that do not establish SNAP's knowledge before the accident and what the actions they did or didn't do. As an example, I'm just
Sure.
whatever came to the top of my mind first.
That's okay.
How
Feel
do-
free to file a protective order on those.
And thank you. You've answered my question, which is, I want to do what the court is asking me to do. And I try to do that all the time, as I said before in my argument, but I need to also do what I need to do to protect my client. And so as we tried to do before the first deposition, and we failed to do at the deposition in terms of objections to the satisfaction of the court, I heard you. I just wanted to know how the court wants to do that. And it's the best thing to do for these topics is to file the protective order to the extent that there are anticipated questions because they were asked the first time that we still would like the court to consider those specific objections to, so that maybe we don't have to pay for it a third time. We can address that with the court before. Is that
Yes.
okay with
What
you?
I'll do is I'll rule on the briefs. So if we're not going to come back here and argue this again. I'm ready to move forward. So file your whatever you want for me to absolutely rule on, but whatever you don't put in there, and then I'm going to rule from the bench. In fact, when you file your motion, send a proposed order with it, saying if I do what you want me to do, this is what Judge Thacker would rule on, and send it in Word format and email it to us. Because when you get it, I'm going to turn it around really quick. So because I'm ready for this to move forward at full speed. So this is what I've been trying to do for many, many months now, and I'm going to continue increasing the pressure on both sides until I see some forward momentum. So those are good questions, Mr. Masterson. Of course, if you have things that you do genuinely believe are protected, file a motion. Not going to hear on it. Rule from the briefs. And y'all obviously will have probably a shortened time to respond, but we'll cross that bridge when we get to it. So, but I'm looking for y'all when you get it to email me and say we can respond within 10 days or, or 14 days or whatever, so that we can keep this thing moving forward.
And so I'll assume that they still want to take the topics in the 28 in the original notice, and we'll move pretty expeditiously in terms of a protective order on narrowing those topics to, it's probably going to be what is relevant to this case, right? And
Yes.
as long as we keep it within that, I think that'll be the limitation of that, but we'll do that as quickly as we can.
Sounds great.
And then they'll respond and we'll go from there.
Right. Okay. Mr. Adams, do you have any other questions for me that I can answer?
We are uncomfortable with having had served a notice in July or August, took the deposition in December, and now in March, they filed a motion for a protective order. It's uncomfortable, but
It is, but I'm gonna rule quickly. You're gonna get your answers quickly, and that way, when y'all get out there, you see what I'm trying to
it's
do?
very clear.
When you get out there, if I haven't ruled on it and I haven't ruled it out, it's fair game.
Understood.
That's what I want to avoid.
Understood.
So that's it.
Understood.
And that's why I'm going to move quickly to make certain that y'all have a rock solid platform for each of you to stand on and say, nope, Judge Thacker ruled that out, or nope, Judge Thacker ruled that in. So that's all I'm trying to do is provide framework and stability for round 2 so that we don't have to do round 3 because none of us want to do round 3.
Understood.
Okay.
May I ask one more question?
Yes.
Just from a logistical standpoint, I don't know what the preference is, but does it matter to the court in terms of the expense of the SNAP is to bear whether the witness or witnesses come here versus paying for the plaintiffs to go out there?
Oh, yeah. I mean, that doesn't matter to me. So if y'all can work that amongst yourselves, that'd be fine. But it never occurred to me to fly them out here, but
Judge, actually, maybe all future depositions should be in Georgia because the obstruction that we got in the first deposition, if applied to fact witnesses in the future, is going to lead us back here again.
it is cheaper to fly one person this way than a bunch of people that way.
Well, Well, unless we have to have 100 out in the hall. So let me confer on that, because I do want to make
Mr.
sure.
Hope, yeah, let's go.
I do
All right,
wanna
you look
make
at
sure,
it.
yeah.
We can talk about that in our conference call. How about
Okay.
that? So I'm not gonna make a carte blanche ruling, but as far as this one goes, y'all talk it, and like I said, whatever is the most cost efficient way is fine. And if y'all have an issue, I'll get involved, and I'll sort it out. But hopefully y'all can sort that one out yourselves.
I heard you, Roy. I'm gonna get involved.
Okay. Mr. Khan, obviously, I can't put you back up on the screens, but I can see you fine. Any
Yeah,
questions for you?
I guess I have a question because, of course, SNAP has to go through the process of again preparing witnesses for this. And is the court's ruling that the deposition, or maybe the court hasn't thought about this, are we addressing every topic that was noticed for the first two depositions, or are we addressing only those topics where plaintiffs didn't get an answer to a particular question?
No, I'm not gonna get that far into the weeds. They're gonna go back and ask the questions that they think they need to ask, because I don't want you to say, well, I object to that question, when in reality, they're just having to ask it to set up a second question. So the short answer is, they're gonna get to ask the questions that they want, and your people are gonna answer those questions. Because by then, you're gonna have my ruling on the protective, so you'll know exactly what you should answer.
Yeah, I understand, Your Honor. I'm just trying to make sure. I understand the court's order. I understand the court's upset, but as I said, one of the frustrations we had was trying to prepare witnesses here for this. And I don't want to be in a position where the court says, okay, you got to depose them a third time because they couldn't answer questions. So I'm just trying to get as much clarity as possible on what they need to be prepared on.
Sure. The short answer is, if you gotta get your people more narrow, bring in the subject matter expert on one topic each. Again, Mr. Masterson said you might have 100 people out in the hallway, but if all you're gonna do is ask them each one question and they're an expert on that question, this will go a lot smoother even with 100 different people. And so what I want to avoid is a whole nother set of transcripts of I don't knows. Because again, I recognize that the responsibility of the attorneys is to get to I don't know. But that level of it was deeply troubling to me. So,
Understood. I mean, I think that the concern you're hearing, Your Honor, is that given the passage of times, the truth might be I don't know, or I don't remember, but I understand your point in terms of the volume.
right.
And we certainly can look at those instances in that deposition and find out whether that's the answer or there's a way to answer it and prepare them on that, and we'll do so.
Yes, and hear me say, that was my initial interpretation as well, was that the passage of time was a little bit gray, but the thing that broke it for me was when the witness came back and said, oh, I spoke with Evan Spiegel yesterday. And I literally went, you have got to be kidding me. So you brought a list, you wrote down the names, and you didn't include the CEO of your company as number 5. And so I'm just letting you know, like, those were the two moments for me where I was like, you have got to be kidding me that this is what happened. So,
Judge, can I clarify something there just so the court understands that the witness and we were operating in good faith? We had decided that for Mr. Cheek's deposition, because the topics were so diverse that he had to rely on a lot of different materials, that we were going to provide to the plaintiff at the beginning of the deposition all of the various materials he had reviewed in the course of preparing for the deposition, so that they would have them there and could ask him about them, and so that he, if necessary, could refer to them. And as I said, Mr. Cheek's preparation, it really also occurred primarily months before the deposition. Mr. Adams doesn't remember it, but Mr. Cheek was supposed to be deposed in November, and not in December. And in the course of that, we also prepared a list of witnesses he had spoken to. And this was prepared long before he spoke to Evan Spiegel. And there was, in fact, no plan for him to speak to Evan Spiegel. I'll put it on myself. I didn't think to go back to that list and add Evan Spiegel to it. And I think Mr. Cheek, who is not a professional witness, simply looked at the list and read off the people he had spoken to. There was no bad faith. There was no sort of misdirection there. It was simply an error that occurs when witnesses are required to be educated or learn about so many different topics and spend so much time preparing.
okay, I get it, but I stand where I said, which is that if you spoke to the CEO of your multi-billion-dollar company the day before a deposition, I think it should have stuck well enough in the head of everyone there to at least write the name as number 5 on the list that y'all provided. As we're all aware, a duty assumed is a duty owed. Y'all created that list and passed it along, and you didn't include everything that needed to be in it, giving them inaccurate information. Okay, so Mr. Khan, I appreciate your point, but I'm not going there with you. So, Mr. Khan, do you have any other questions or need any additional access to the record on this issue?
No, I mean, as I think as Mr. Masterson made clear, that to protect the record, we will want to file a motion for a protective order, particularly with regard to Mr. Spiegel, because I think that's what the statute contemplates, that there'll be a notice of deposition and then a motion for a protective order, and that will be ruled upon in the context of the statute. And so we're going to file that motion.
Okay,
So
and obviously,
for our record, and we understand that the court's going to rule upon it promptly.
yes.
And
I guess
Judge, one of the
I
points
heard
where
that.
nobody is surprised about this is that Mr. Spiegel is right now on paternity leave. No, I don't
Well,
want that to come as a sudden shock.
y'all give me just a second. Hold on.
Congratulations.
All right, Mr. Khan, what I spoke with Mr. Habe about was that obviously I expect you all to consult in good faith, about the questions that will be asked of Mr. Spiegel, and frankly, the questions that you all wish to stand on with the objections from here. So I do not expect 100 objections. What I expect is the couple that are left that y'all can't sort out that I'm going to work on. And I also, obviously Mr. Spiegel's out, but the fact is that y'all, I was going to give y'all 30 days to file your response, to file, because since I'm giving you 2 sets, I'm going to give you 30 days to go ahead and do both of those. One is your 30B6 objections, and one is your Spiegel objections. And then to have y'all talk, see what you can work out, and then I'll rule on what's left. So, because again, I'm ready to move forward, and again, I'm withholding attorney's fees on this, in the hopes that y'all will keep up with the fact that I'm keeping a very close eye on this. So, Mr. Masterson, anything else?
Yeah, that I do want to clarify that just to make sure I do what you ask. So it is true, right? If the answer is, I want to know, if the question is, I want to know this specific thing, I will make sure. Like if I know that question's coming, meaning they tell me, I will make sure somebody can answer it, or the answer is we don't have an answer for it. But I can't predict them all, okay? I'm going to disappoint somebody in this process, I'm sure. However, I get your Honor's point. But what I want to make sure that we do right, and we'll brief this, is I'm happy to talk to them. The protective order is in large going to be based on the questions already asked. Like we know they want to know that, and we think that that's not an appropriate topic for this discovery. And we'll try to limit it to that, plus what we would anticipate related to the other topics. We'll try to keep that as narrow as possible and as high level so that we get some guidance from the court that's meaningful to both sides, so we don't have to call you 10 times during the deposition. Understood that. What I would ask the court's indulgence on is in terms of filing the protective order on Mr. Spiegel, as I said earlier, and I do understand your Honor's ruling, it might be more fruitful to do that when this deposition is complete. And I say that only because then we'll know whether the question was answered by somebody else or not to the court's satisfaction, and I guess their satisfaction. That will allow us to narrow down what Mr. Spiegel actually is to testify about to the things that actually are unique to him, as opposed to something that's already been answered by the company or another witness.
All right, so the short answer is I'm not going to rule on that either way. Y'all need to talk about that amongst yourselves as to scheduling and what comes where. And again, if I have to get involved, I will. I'm trusting that you all understand my expectation is to move forward at full speed. Yes.
I do have a concern, though. It sounds like, I hope the court does not feel constrained to have a notice and a protective order and then a ruling, because Snap already said we're not giving you Evan Spiegel. So we filed what we would put in a response to a protective order. It's been fully briefed, it's been fully heard, the court has reviewed the transcript. If we need to retroactively serve a notice and attach it to our motion, I don't think, I think that's an artificial step. The court has already heard both sides.
No, I'm ordering you to go back and do the thing that you originally were trying to do. There's not a
Okay.
new notice here.
Oh, it sounds like Snap is saying now.
I'm saying these depositions are insufficient by the
Yes,
court's ruling. And I'm saying you need to just go back on the thing you originally filed.
Yes.
Go do those depositions again.
okay, I hear Snap saying we want to file a protective order on Spiegel. I thought I heard Mr. Khan say that.
Yeah, that's
we are.
correct on Spiegel. Yes, we'll file a motion for protective order.
And I said that I would file it, y'all talk, and then I will rule quickly. So that when y'all get out there, again, I can't let Spiegel be the Wild West.
It will be.
I can tell you the guardrails are gonna be about this wide, because frankly, at this point, I'm really frustrated at basic questions that should have been answered, that I know Spiegel can answer, that y'all didn't get your people to answer. So that's why I'm saying, and for record purposes, I'm holding my hands as wide as they go, because at this point, there were several moments when I read it that I thought, Spiegel knows the answer, let's just depose him.
Okay, I don't think I was suggesting what they were suggesting. I was suggesting we're going to file a motion protective order on the corporate representative deposition based on their current notice. They don't have to do a thing else. We'll do it within 30 days. The court, they will respond, and the court will rule accordingly to that motion. You've also asked that, or we've suggested that we want to, Your Honor has said we are to file a protective order on Evan Spiegel. I've asked that we do that after the testimony is completed, the corporate representative. We can do it at either point, but what I heard Your Honor say is y'all need to talk about that. And so what I hear Your Honor saying, and what I would ask the plaintiffs to do, and I promise I will do my best to narrow my protective order to, if they'll do this, is tell me what it is they think he knows, what topic. I mean, they don't have to write out the questions. That's not what I'm asking. But tell me what it is they think, and tell the court what it is they think Mr. Spiegel has unique knowledge that he needs to depose on. And I will limit my objections based on Your Honor's prior ruling to the things that we believe ought to be in that protective order.
Well, you can certainly go through the two depositions, because I certainly had a list of questions that I knew were easily identifiable from the two depositions.
For Spiegel?
Yeah, for Spiegel. There were so many moments where the witnesses said, I needed to talk to Evan, I needed to talk to Mr. Spiegel. So there was a ton of those. So again, I'm not going to put the guardrails tight in on the plaintiff here.
Yes.
Just from a timing perspective, I understood your order to be that the defendant will file a protective order on both Spiegel and the 30B6 within 30 days.
That's what I said.
Okay.
Because I was going to do it, I was going to shorten it down to 10, but when I added both, I pushed it back out to 30.
Fair enough.
Because I thought I'm asking y'all to do two things at the same time, so I'm going to give you the normal amount of time, but frankly, we got to get moving. And then again, I'm looking for potentially, once y'all see it, I'm looking for the things you can consent to. Because again, I'm certain there's going to be a bunch of stuff in there, and I do not expect to have to rule on all of those. If I have to, I will. But I'm expecting y'all to have some sort of discourse that allows y'all to sort this out. So, but if we need to have a conference call, we can have a conference call. We do that already. So, again, I just am ready for this to move forward. Okay, do y'all have anybody have anything else you need before we adjourn?
I want to make this right.
Oh, yeah, we do. I'm supposed to set a date on the McGee cell phone question. That's why Mr. Hope is here. Does April 19th, y'all check your calendars real quick. See April 19th, come back here. And Mr. Khan, you have standing permission to report virtually on all court dates, okay?
I'm sorry, Your Honor, you broke up just there.
I said you have standing permission to report virtually to all court dates.
Thank you, Your Honor.
I think I'm in trial.
We could do. All right, I tell you what. All right, y'all just look at the 19th. If you got anything concrete, email us, let us know.
Yeah, I have a trial that's especially set on the 15th. I have no more idea than anybody else whether that's going forward, but I'll notify the court. We can set it for now. If I'm in trial, I'll let you know.
Okay.
So you're in March 19th, Your Honor?
April 19th.
Oh, April 19th.
And of course, we have, we could also do the 12th. If you really need it, I really don't want to do this, but I could maybe think about the 26th, maybe. But I could definitely do it the 12th and the 19th. So, all right, so those are your 3 dates in order, 19th, 12th, and then 26th, but please don't make me do that unless we have to. So, what?
How about a deadline for?
Yeah, so how long do y'all need to know? Does that work for you, the 19th?
That's fine with me. Yeah.
Because obviously that's, y'all are the center of that here.
I'll need to check with Ann too.
That's fine.
I've asked for a deposition date for Mr. Persinger and they haven't responded to me.
Okay. Y'all talk about
Since he
it.
gave an affidavit in support of it.
We might want to have a status conference in between now and then, because they haven't told us they're accident reconstructionist either.
Well, let's,
And we have some concerns
how
about,
about, when is our next calendar? I mean, when's our next conference call?
we don't have one as I'm aware of.
Oh, well, let's pick one. Let's see, today's the 8th.
Well,
22nd works for me. I'll look at your calendars, 22nd at 2 p.m. for a conference call.
Does that work?
Well, they gave an affidavit, yes, but while we're here, if he's objecting to let me depose the person who's the affiant, so that the court has, I mean, you gave an affiant, don't I get to depose that person?
Well, check.
Yeah, it's just that he is an expert, so we don't want him to be deposed twice unnecessarily.
Well, I can probably do it all at once.
Huh?
I can do it all at
We,
once,
see,
Michael.
the problem is that we don't have the facts to present to our experts
About what?
about data, because we haven't been able to get straight answers from SNAP about things.
All right, well, let's do this. I'm putting y'all down for 2 p.m. Or actually, I'm gonna let y'all do it. 2 p.m. on March 22nd. Y'all have that conversation. Again, I'm not at all troubled by the idea of deposing this expert twice. We've had this same conversation 60 times where one side is worried about 2 depositions. I say go ahead. And this is the first time we've actually had to do 2 depositions. And frankly, we're doing 2 because I'm ordering it. And so, yeah, I'm good.
I understand.
No objection.
Get it going.
That's fine. Does SNAP need to respond to the motion? I mean, they're asking for sanctions against them for fraud or spoliating this fund. I know you don't want to hear that now. I want to know whether I need for record purposes to do it, because I think, right, the implication is they want a charge that if we had the phone, it would show, let's just say their best argument, she was using Snap, okay? Snap's never had the phone. We didn't control the phone. We didn't destroy the phone, didn't tell anybody to destroy the phone. And Ms. McGee testified she never spoke to any lawyers from Snap or Snap themselves at any time. So we didn't have anything to do with that. And so if we need to brief whether or not they're trying to get a sanction that actually hurts us, then we'll need to brief that.
Do y'all anticipate in any way arguing, or is that in any way part of what y'all are thinking?
I would say, I'm not getting over my skis here, but my general impression, without having to look closely at it, is that spoliation by one party does not prejudice another party.
That was my impression. So
Excellent.
what you
You
just
can
said,
give instructions to the jury that any sanction for spoliation is to be considered as to
that
that party.
yeah, okay.
I
We're
understood.
legally all on the same page then as to what the law is. So the short answer is, if y'all just want to file a one-liner that says whatever, but I don't see any reason.
I think we're going to join it.
So,
I mean, these two parties, the plaintiff and them, had access to it, did not preserve it, and I think it prejudices us because it hurts our defense. So I think we're leaning towards joining in the motion and adding the plaintiff's fair to do so. They've sent a spoliation letter, Your Honor, in about 8 months after the accident or so, and they waived their constitutional rights, and they didn't do anything to preserve it. They didn't even hire Mr. Persinger until 2023.
All right, we will argue all of this then. I promised Ms. Gower that we would not go into the weeds here today, because she is somewhere on a beach or at Disney World or in the mountains, and I don't want to have to explain to her that we pre-argued the case.
We ruled.
So so the short answer is that we will cross this bridge on the 19th when we come back, assuming everybody's there. Because again, you're not the center of that hearing. The key person I need to know is Ms. Gower. Is Ms. Gower available? So, all right, and then obviously we have a calendar call now. A conference call scheduled for the 22nd of March. So,
Could we get a ruling on a definitive date for McGee to respond to our motion? The last Friday in March would give us 2.5 weeks, just to see if there's anything that comes up. I'm not sure what could, but.
do you, Ms. Rutledge, have you spoken with Ms. Gower about the time needed for the response? I think she emailed that she wanted the full time, but I couldn't remember if that was that or
She
something.
did send that email, but I haven't spoken to her about it.
Give me just a second. For the defense to respond is March 28th, Thursday, March 28th. The reason I picked that is 29th is Good Friday, so I don't want to lose the next 4, get us into April. So Thursday, 28th is your deadline to respond, and that'll give